Okay, well, I'll direct my, go ahead.
Your Honor, I'm actually here on behalf of Andrew Haas. We're from the same office, so I'm here personally.
Oh, okay, great, thank you. Well, I'll direct my comments to all counsel, and when we start the next argument, I'll give counsel for the next case a chance to ask questions. I'll give you two a chance to ask questions now. I know we both have experienced counsel here, and you've argued several times before, and you've received a written copy of our instructions. But if you have any questions about them, feel free to ask them now. Seeing none, I'll remind you to state your name and attorney registration number when you get to the lectern, and of course we have 15 minutes per side. Appellant could try to reserve some time, but I ask you to keep track of your time with the clock on the lectern. And please, I don't know if this is relevant here, but please maintain the confidentiality of any juveniles' names, sexual assault victims, and any other information that you don't want publicly released. And I think with that, I want to ask everyone in the courtroom to turn off any cell phones or similar devices so they do not disturb the attorney's arguments. And I think with that being said, we're ready to hear argument and People v. Maez, number 15CA1764. And counsel may proceed when she's ready.
May it please the court. My name is Inga Nelson, registration number 47620, and I represent Mr. Maez, who is here with us today. This case requires a straightforward application of the existing case law addressing ineffective assistance of counsel for failure to perfect an appeal. The Attorney General has conceded that the trial court erred when it applied an incorrect legal standard to deny Mr. Maez's 35C motion for ineffective assistance of counsel failure to perfect an appeal. When this is the type of ineffective assistance that is alleged, the correct standard requires the defendant to establish three things. First, that trial counsel's representation fell below an objective standard of reasonableness. Our Supreme Court has made clear in People v. Baker that where trial counsel was counsel of record at the time the notice of appeal should have been filed, they are obligated to ensure an appeal was perfected, and the failure to do so amounts to ineffective assistance of counsel.
Doesn't the people concede that?
Mm-hmm.
The people concede there was ineffective assistance of counsel. The people concede that the lawyer, whether he got more money or not, should have filed the notice of appeal. Mm-hmm. Isn't the only matter we're here, I mean, I appreciate your argument and all that, mm-hmm. but isn't the only matter that we're here today is to figure out what do we do now? Do we send it back for another hearing, or you would like us to, allow an out-of-time direct appeal to be filed? And I take it that would require a new notice of appeal or not?
Correct. I believe that this court could order that a new notice of appeal be accepted out of time.
Out of time. Because the one that was filed was, I think it was dismissed by the motions division, if I'm not mistaken. So we would need a new notice of appeal specifying whatever the issues are that Mr. Maez wants to appeal.
Correct.
Okay, so basically you're asking us to direct an out-of-time appeal, allow an out-of-time appeal to be filed. That's
correct. Yes,
okay.
Which is the ultimate remedy that would be sought.
So let me just ask you a couple questions still about the ineffective assistance, if I may. Defendant says his lawyer should have filed a notice of appeal before. Is there anything in the record? Is there any assertion by defendant in his Rule 35C motion where he asserts that he told that lawyer he wanted to appeal?
I believe there's an assertion in the motion that he understood that would be happening, but that
he understood
trial
that
counsel
in appeal.
did not.
Well, how do you understand that? Because he also says the judge didn't tell him.
Right, which the record reflects. If you look at the sentencing record, the trial court did not advise client of his right to an appeal, did not advise him of the time frame for filing a notice of appeal, or that he had the right to appellate counsel. And
all right, so let's assume that's the case. The judge never told him. What ties in to show that he then asked his lawyer for an appeal if he didn't even know that he had a right to appeal?
Right. I think there are several things in the record that show that. One is Mr. Miles' own pro se filings at the point at which the 35C was denied. Mr. Miles filed several pleadings with this court seeking to get appellate counsel appointed. He stated in the original notice of appeal that he filed with this court before we filed an amended notice of appeal.
Let me stop you. You said that was after the 35C. My question was, in the 35C motion, did he allege, and more importantly, really, did the trial court ever find that he asked the lawyer to file an appeal? It
Right.
seems like that's an unresolved fact.
I have two answers to that. I think that the
Two very
fact that Mr. Myers hired a second private attorney to find out what was happening with his appeal when he had not heard anything, and that is the premise of the 35C, in which his 35C counsel states that he contacted the Court of Appeals to find out what was happening with the appeal, contacted trial counsel to find out what was happening with the appeal, and found that there had not been one.
Okay, I
that
agree.
that is
Those are
an
indicia-
allegation.
Those are indicia that Mr. Mays wanted to appeal. But the issue before us was his counsel ineffective for failing to file an NOA? And if the counsel wasn't asked to file an NOA or told to file an NOA, and if maybe he wasn't because Mr. Mays didn't know he had a right to appeal because you say the judge didn't tell him, it seems to me we still have to resolve that as a factual issue.
Well, I don't actually think that that completely encompasses the trial counsel's duty at that point. I believe that the Baker court reads that as a broader duty to advise and continue the representation until the point that under 44, the CRIMP 44E representation has ended. And if that is the case, that trial counsel, if they're still the counsel of record, they have a duty to advise the client about their right to an appeal. And so I believe from the fact that he was trial counsel, he was still the counsel of record at the
So let me
time.
stop you there. So then you say the counsel was ineffective. Now you're saying, I think the counsel was ineffective because he didn't advise Mr. Mays of his right to appeal.
He was ineffective for failing to perfect an appeal,
All right.
which is exactly the facts that occurred in
All right.
Baker.
Is there a finding by the court that the lawyer did not?
The
a
court
advisement?
assumed that all of the allegations were true. And we know for a fact, looking at the record of this case as it proceeded in the Court of Appeals, that no notice of appeal was filed.
No, I know.
But that assumption is for purposes of determining whether or not it should be summarily denied. And so what the trial court erred here and the people concede is a hearing should have been granted to flesh these facts out to determine whether or not there was ineffective assistance rendered and whether or not that was prejudicial. Prejudice being not filing the appeal, not the merits of the appeal. And so what is your authority to say that we, reviewing a summary denial of a 35C, can not only direct it to go back down to the trial court to have the hearing, but also actually affirmatively grant the relief that you are requesting at the conclusion of that hearing?
I think both Baker and Long speak to the fact that if you can establish the prongs that are the required prongs from the record, and the standard is not a high standard for establishing this. It is by a preponderance of the evidence, or that there's a reasonable probability that client would have filed a timely notice of appeal. That is not a high standard. And so if you can, by inference from the facts that are established in the record,
Sounds a lot like appellate fact-finding.
well, and when the record is complete enough for that to occur, that is appropriate. And that is what the Baker court found. And
Baker
the
was
Long-
postured different. I
was
apologize.
postured
I
differently,
apologize
yes.
for interrupting, but Baker was postured different. That was an attempt to file a direct appeal out of time,
Correct.
as opposed to how you're postured in front of us is appeal of a 35C. Now, I think the rationale of Baker had a lot to do with why are we going to just deny this jurisdictionally, send it back down to do a 35C only to come back here. But that posture is important. I mean, you're in the posture that was elected by the defendant, and so you just have to finish it out, go back down, prove ineffective assistance, and get it, have your right to a direct appeal, which shouldn't take that long, right?
Well, my experience with getting evidentiary hearings on remand is that it does take some time. And the fact is that Mr. Mize has already served a number of years in the Department of Corrections without a direct appeal on his conviction and sentence. That and a delay of an additional year or so to send this back down to the district court before it can come up to begin his direct appeal is not in the interests of justice or finality, because at that point, there's little.
Then I'm going to circle back to what I asked before. Where's our authority when a
Right.
case just postured like this
And
to grant you the relief that you're requesting?
I think you can draw from Baker, and I think you can draw from Long, the opinion of this court, where both stated that where there are facts on the record, you do not have to remand for an evidentiary hearing if you can find by inference from what is in the record.
But only one side has presented their facts at this point. I mean, isn't that a little bit of a problem? We don't know what the people would say. I mean, maybe the people just stipulate to this and we can all go about our business of just trying to get this to finality. But we really don't know what the people, did the people respond? Because it was a summary because it was a summary denial, we don't even know what the people's response would be. If the facts would be disputed, where they're at with that, right?
I mean, I don't see that the facts would be disputed. They had an opportunity to dispute them, and they
Did
didn't.
they? That's actually, that's
Well-
a real question. Did they? It's a summary denial. Isn't the process filed 35C? If there's merit to it, then we send it to the prosecution for a response and appoint counsel. Here, there was a summary denial without appointment of counsel, so it probably wasn't even sent to the prosecution for a response, right?
Well, he did have retained counsel at that point, so
But
I do not actually know,
But the people didn't
frankly.
file a response, right?
Yeah, the people didn't file a response.
So we
and I
don't really know what their
about that.
position is.
But I think we do know from the record that there was trial counsel of record. He had an obligation under our rules to advise and perfect a notice of appeal. That did not occur. I don't think that those facts are going to be disputed. There's no indication of that.
That's a
And
big issue. There's a big difference, isn't there, when they're in front of an appellate court that doesn't have that sort of fact-finding role?
I believe that from what the evidence that we have in the record clearly establishes ineffective assistance of counsel, because there was an obligation under Baker, under Crim P44, for trial counsel to perfect an appeal. One did not occur, and very quickly afterwards,
Well,
Mr. Mize.
But if the client doesn't want to appeal, the counsel doesn't have an obligation to appeal. And I know you said, Mr. Mays has said repeatedly after the 35C he wants to appeal, but you haven't told us that at the 35C
I believe
he said that.
the entire point of the 35C was that he wanted a direct appeal and had not yet had one. And that is an assertion that he wanted to appeal his
Let
conviction.
me ask you
sentence.
a little more troubling question, I think, for your side. I'm going to ask the people in a minute, too. If we send it back and the judge finds that there was ineffective assistance of counsel, that he had asked for an appeal, that one should have been filed, now what? We're years past the date for filing an NOA. Do you think the judge has authority, the trial judge has authority, to allow an out-of-time appeal?
Well, I think that that is exactly why in People v. Baker, our Supreme Court said that the appropriate route for dealing with this is to accept a direct appeal out of time
Well,
because
that's
of
when
the
it's already been
delay.
filed, but that's when it's been filed.
Right, but they spoke specifically about how a 35C is not an ideal or appropriate remedy for this issue exactly. And that is why they said that in that case, which had also proceeded for years by that point, that it was best to accept an out-of-time appeal instead of directing this toward the 35C route, because it is not efficient, it was not in the interest of finality or justice, and I believe that, yes, that has been said by this court before. This was said in Long, that the trial court could then direct that he gets a 35C, a direct appeal.
Long is authority, your position is, long is authority for a trial judge on a Rule 35C ruling to also order that the appeal can be filed out of time and accepted by our court. You think the trial judge has
I
that
believe that
authority?
that is what Long says, yes, because there are a number of things that needed to be found, including who counsel of record was at the time that was remanded back. And so Long laid out a number of various different options depending on what facts were found. And one of them was that they could attach that ruling, the court's 35C order, to an amended notice of appeal in order for it to be accepted.
What about Lancaster?
I don't believe that was cited.
Well, that's because it came out after the briefing closed. But that was a case in which counsel had withdrawn, or had a fee agreement that said he wasn't obligated to pursue an appeal, but under Rule 44, that wasn't a proper withdrawal, so he was still counsel of record, failed to pursue the appeal. The trial court held a hearing there and still found that there was not ineffective assistance because of this fee agreement. We reversed and ordered an out-of-time appeal. But doesn't that indicate that, given that we reversed the trial court finding that it was erroneous not to allow them to reinstate the appeal, isn't that implicit authority of the trial court, upon finding an ineffective assistance, would have the authority to authorize an out-of-time appeal?
Yes.
And if we disagreed with that up here, then we would just reverse the court's order, because people could appeal that, right?
I would assume so.
Okay.
I'd like to reserve the last minute for rebuttal. Thank you.
You may. Thank you.
May it please the court, my name is Brock Swanson, attorney registration number 39116, and I represent the people of the state of Colorado in this matter. When a defendant raises a post-conviction claim under CRIM-P 35C that depends on factual allegations outside of the record, relief should not be granted before there is a hearing. And here the people agree that the defendant has stated a claim, but that claim depends on factual allegations outside of the record. So the appropriate remedy is to remand for further proceedings. And
What are the facts? What are the disputed facts that need to be resolved? In
the facts, I believe, that would establish the claim are that trial counsel failed to adequately consult with the defendant about whether to appeal, and then that after a proper consultation, the defendant would have appealed.
And that's it. You agree that the Strickland standard doesn't require anything about whether he was prejudiced because of the merits of the appeal, right?
That's correct.
So, counsel, just to be absolutely clear,
Sure.
so the people at this point have not conceded that trial counsel was provided ineffective assistance of counsel.
That's correct. We don't have information in the record sufficient to determine whether the factual allegations are true, and the prosecution in the trial court has not responded and had that opportunity.
Would they contest?
I don't know.
Why not ask them at this point? I mean, what are we doing here? I mean, this is angels dancing on the head of a pin. This is not good for the system. It's not good for the victim. It's not good for the defendant. I mean, this is postured in a way that what's required next is for below, had this proceeded according to plan, is that the prosecution then be told to respond. And the prosecution can respond in one of two ways. They can contest it, or they can demand a hearing, or they can just concede it. Why don't we know that at this point?
We don't know that because the trial court summarily dismissed it, and we did not get to that step in the proceedings.
We also don't know it because you haven't asked. Is that right?
I believe even if I had asked, it wouldn't be appropriate for me to make those factual allegations or concessions.
Why
on
couldn't you make the
appeal.
concession? If
If
you're
I can
ultimately
back
going to
up just a
concede it,
second.
you know, in 4 months, why couldn't you make the concession up here and we just allow them to pursue the appeal at a time, and it actually is beneficial for everybody?
Yeah,
I'm confused.
Let me back up just a second, and maybe this will be an answer to that. And that is that what CRIM-P 35C outlines as the procedures that would be followed here include that we would give the public defender an opportunity to add additional claims, and then that the prosecution would be directed to respond to all those, and then hold a hearing on any disputed facts necessary to resolve that claim.
Well, but
So I
let's
think
say that there were other 35C claims, you know, trial-related claims.
Right.
Those would all be subsumed and held for a later day if he was denied his direct appeal right? Because you would first just pursue the direct appeal and not pursue the other related 35C claims until the direct appeal is resolved, if he's entitled to it.
I'm not sure that that is correct.
Isn't that the posture of Lancaster?
I don't know I did look at Lancaster. I'm not sure if that's the posture in the sense of,
Well, Lancaster raised a bunch of substantive 35C claims, as well as an ineffective assistance of counsel for failure to pursue an appeal. And all this court did is reinstated the appeal and said, we're not reaching the other substantive claims because you need to do the appeal first.
I guess
Maybe
I
it
would be
gets mooted.
concerned that, what's this? If the court has only ruled on the appeal aspect of it, then we don't have a final order because he hasn't, for appealability purposes. But
So the appeal gets reinstated and he has a 35C right after the direct appeal is
Yeah.
resolved. And you can raise successiveness issues and the like, but we do the direct
I
appeal
guess it's
first.
like, I'm not sure that that the direct appeal has to precede the resolution of the other claims. If the defendant has claims of ineffective assistance of counsel that he wants to litigate then, and that would entitle him to relief, and they're already in the trial court and in a posture where we've already had this briefed and decided, then the court could address those before we get to an appeal, and then those could also be put together into his direct appeal, also the appeal of his 35C proceeding, which is like what we do in death penalty cases with a unitary appeal, where we do the 35C and the direct appeal, do the 35C before the direct appeal, so that all of those can be considered at the same time. So, let's say this. If we're gonna go back down and the prosecution has an opportunity to interview the defense counsel and decides to concede these issues or anything, I think that it will be a very short procedure, especially in the terms of the timeline of how long it takes an appeal to occur as far as judicial economy occurs. And if the defendant, if this happens and the defendant wants to request a expedited briefing, we already have the record developed, and both of us are familiar with the case, so I don't think we would have any objection to that, so that this appeal could be processed more quickly on appeal.
Wait, how does it get back here, though?
Okay.
So we go back to the district court, he says, okay, it was ineffective assistance of counsel, the guy should have filed, but now we're 2 years past the time to file. So what does the district court, what authority does the district court have then?
So in People versus Long, how they address this is they said that if the court finds that it makes a finding of ineffective assistance of counsel, the defendant then files a notice of appeal, an untimely notice of appeal, requests this court to grant, to find good cause for the untimely appeal, and as justification for good cause attaches the ineffective assistance of counsel. So it'll still be up to this court
Up to us,
to
not to the
decide whether there is good cause. I think Long indicates that if we have this finding of ineffective assistance of counsel, and Baker, that under Long and Baker, if we have a finding of ineffective assistance of counsel, that does constitute good cause, which would then, this court would abuse its discretion if it didn't find good cause for the untimely appeal at that point.
Had the allegations in the 35C been made instead in a motion to accept an out-of-time appeal to this court on a direct appeal, wouldn't we have accepted the appeal and allowed it to proceed based on Baker?
Well, I'd say two things. The first I would say is that that was done in this case, and
But it was done
the motions division.
But was it
denied
done after this appeal was already pending?
It was done, he filed an appeal, and then he filed a request to file an amended notice of appeal that would include an untimely direct appeal. And this court did not find good cause under the circumstances of this case and granted. And going to the merits of this ruling, if this court wants to consider that, as Baker and Estep, which are both cases that were postured like that, where it was a good cause finding for an untimely appeal. Both of those cases noted that a hearing is still necessary before finding good cause, and in many cases, indeed, Estep says most cases. And I'd say this is even if that were the if you're considering under that posture, the appropriate thing would still be to remand for a hearing, because this is not one of those cases where good cause is so firmly established by the record that a hearing is not needed.
In Baker and Estep or similar cases, were the facts of the motion asking for this court to accept an out-of-time notice of appeal, were those facts disputed, or were they conceded by the Attorney General?
They were not disputed, and they were not just allegations, they were actual facts within the record that established the ineffective assistance of counsel. So in Baker, we had defense counsel actually did file a notice of appeal. He just filed it in the wrong court. And then we had also a letter from him to the defendant saying that he was not going to help him perfect his appeal. So we had these things in the record that affirmatively established the ineffective assistance of counsel. We didn't just have the allegations of the defendant in his motion. Estep is similarly, we had a number of uncontroverted facts there. The situation was really, it was really involved, but we had defense counsel in court saying, we want to file an appeal. We're trying to figure out how we can do this because we also want I believe it's sentence reconsideration to be done before the court reappealed and the court lost jurisdiction over it. And so they made attempts to extend the deadline, and they just messed up the scheduling of the deadline. So it was absolutely clear on the record that the defendant wanted to pursue an appeal, and it was the trial counsel putting the wrong number of days in its requests for extensions of time to appeal that resulted in the appeal not happening. So we had the record affirmatively establishing those facts already in those cases, but those cases are really the exception rather than the rule. We need to have that record, and we just don't have it in this case yet.
So it seemed at least one of the important facts that you recited was that this court had heard directly from trial counsel via the trial counsel's motion explaining what he or she had failed to do and what the defendant had asked him or her to do.
In Baker.
Yeah, I mean, I don't know that it's necessarily even that they'd heard directly from trial counsel as much as that this information about what had happened was in the record, even independent from the allegation that you should grant for good cause. These were already things that were in the record.
How were they in the record?
Like we had in the trial court record the notice of appeal that was filed by trial counsel.
But the letter, the letter was not in the record, right?
I don't know that the case is clear exactly about how that would be in there, but I mean, it may have been something that was attached to the post-conviction motion or something
Right,
like
but
that.
it
We don't have in this
doesn't make it
case
part of
any
the-
affidavits or anything like that would be, other than the factual allegations on their face.
I'm sorry to interrupt you. Please
Sure.
finish your answer. Okay. So for example, hypothetically, in this case, if the defendant had attached to his 35C motion an affidavit from his trial counsel agreeing to all the facts, saying, yes, he asked me to appeal, I refused because he wasn't paying me or something to that effect, could we just grant relief on appeal based on that?
I think you would still, I think there would still be a need for the prosecution to be able to respond, but if the prosecution responded and didn't contest those facts, then that would be adequate to grant without having a hearing.
Can we reconsider the motions division disposition of the motion?
I believe you can. You have, there's law of the case, but because this is an equivalent court, it is discretionary rather than any kind of binding ruling.
And what was the nature of the people's objection to the motion?
Sure.
I just don't remember.
And let me, the objection is rather short, but I'd like to go through the three steps, the three factors that they identified in Baker as regarding good cause. And those are the potential prejudice to the people, judicial economy, and the propriety of requiring the defendant to pursue other remedies. And the objection that we filed really goes to the third one. But I think all of the
What's
factors
the third
in
one?
this, the propriety of requiring the defendant to pursue other remedies, which was that the defendant did not attempt to, our argument was that the defendant did not attempt to file an untimely appeal after he retained counsel. He had decided to file a post-conviction motion instead. And that's generally his one opportunity to present all of his post-conviction claims, and because he chose that avenue to seek relief, it's appropriate for him to continue along that path, that it could have been a strategic decision that he wanted to do that because he had counsel when he was making it. I think the other factors also support in this case, which is that this is not a case like in a Stepper Baker when they were talking about prejudice to the defendant. What they talked about is the fact that the prosecution was always on notice that he wanted to appeal in those cases. They had that at sentencing. They had notice that he wanted to appeal, and here we didn't get it until I think it's like almost 2 years after the. And we also have a victim who is an at-risk victim that's very old. So
Isn't there a little bit of an irony then in you asking for this to go back down and go through an additional process, which could add up to a year, when part of your objection to allowing the reinstated appeal was delay?
yeah.
Do you understand that seems like you're trying to ride two inconsistent horses?
I think it goes to the it also comes into the judicial economy there, which is that if he is entitled to an appeal, then yes, but we don't know that yet. And if he isn't entitled to an appeal, then it is, of course, because he made a decision not to appeal, then it would be, we don't have that appeal happening at all, as opposed to it being years later. If that makes sense. I see I'm out of time. Thank you.
Thank you, Mr. Swanson. Ms. Nelson, you have almost a minute.
To your point, Judge Welling, I do believe that this court could reconsider the motions panel ruling if you wanted to go down that road. That would be consistent with the case law around Baker. The facts in this case were very similar to the facts in Baker, and the good cause prongs would also be incredibly similar. And so, yes, really the motions panel should have accepted our notice of appeal. And how that went down is that Mr. Mize filed a pro se notice of appeal, then had to petition multiple times in order to get counsel appointed. Once we were, then we filed a amended notice of appeal asking for an out-of-time direct appeal.
And it was denied by the motions division. Why?
Yes.
I forget why.
They did not provide
No reasons given.
details.
We usually don't do that. Okay.
And I notice I'm out of time. I would ask that this court reverse the district court's 35C denial and order a direct appeal be taken immediately. Thank you.
Thank you. Thank you to both counsel for your arguments. They will be very helpful to the court. The case stands submitted and a written opinion will issue in due course, and counsel in this case are excused. I will give counsel for the next case a few minutes to set up a counsel table. Thank you. case, which is in remarriage of Smith, number 18CA0082, and council may proceed when ready. Thank you.
Good morning, Your Honor. If it's may please the court, I'm Bill Van Horn, attorney number 17092, representing husband respondent appellate Thomas Smith. With me is Mr. Thomas Smith. Would like to reserve time for rebuttal. 3 points, Colorado case law on conscionability and special agreement, separation agreements, public policy about enforcing agreements, and that the trial court did not follow Colorado law in determining waiver of maintenance was not enforceable. Colorado law regarding unconscionability, the separation agreements. The Colorado Supreme Court addressed this case head-on in the Manzo case. In the Manzo case, the parties agreed they'd sell the marital house, wife would get the first $60,000, husband would get the remainder, which they thought would be a little over $60,000. Well, it didn't turn out that way. Wife got her $60,000, husband got about $10,000. The trial court found the result was unconscionable. However, the Colorado Supreme Court overturned and held in order to find a finding of unconscionability, there must be evidence of the record of some overreaching on the part of one of the parties, such as which results from an inequity of bargaining power or under other circumstances in which there's an absence of meaningful choice on the part of one of the parties, together with contract terms that are unreasonably favorable to the other party. In this case, the Smith case, the trial court found that the husband had not done anything that was fraud, overreaching, concealment, or sharp dealing. So how did the trial court find the agreement was unconscionable? Trial court relied heavily on the case of Thornhill, which didn't follow the Colorado Supreme Court, but held even when the trial court finds no fraud, overreaching, sharp dealing, we're still required to review the agreement to whether it's fair, just, and reasonable. Well, Thornhill is not consistent with the Colorado Supreme Court, and indeed, Thornhill has not been cited by any other court for this precedent. Indeed, Thornhill was later overturned by the Colorado Supreme Court on other grounds. Yet even in the Thornhill case, the facts were the wife did not have a good understanding of the value of the marital assets, and she was assisted in negotiating the separation agreement by the person who was the chief financial officer of husband's business, which was also wife's father. In the trial court's decision finding the separation agreement was unconscionable, the trial court referred to the Thornhill case multiple times, and wife cited that Thornhill case many times in her answer brief. Public policy. Let's very briefly consider facts of this case. Here, wife drafted the separation agreement, presented it to husband, wife signed it, had it notarized, and wife filed the separation agreement to the court. Wife is a CPA, not just someone who passed the CPA examination, but someone who practiced as a high-level CPA for many years. Wife did the tax returns for the parties, knew the financial situation. Wife is also a doctor of veterinary medicine and practiced as a veterinarian successfully many years. She'd earned $74,000 a year working for a nonprofit. The Bureau of Labor Statistics, which the court accepted as an exhibit, shows the average income for a veterinarian is $88,000 a year. Wife had no debt, significant assets. Now, husband makes significant income, but he's blind in one eye. He's going blind to the other eye. What does his long-term employment look like? Husband owned a house for 8 years before the marriage. He put that into the joint names. If you take the value of this largest marital asset out, the distribution of the marital assets is 58%, 42% for husband. Wife is so blessed by the financial circumstances and has so much ability to work part-time due to her professions. She was able to quit her job, work part-time, join the local golf club, and with a stated desire to play a lot more golf. Is wife's financial situation unconscionable? Does it shock the conscience as to what she agreed to? I've met many times with potential clients who have signed agreements but now want to back out of them. I tell the individuals, you reach an agreement, you're bound to it. Could the person get a better agreement? Possibly. The Hunt case and the concurrence said there's a strong public policy to enforcing agreements. With agreements, the parties can move on with their lives. With agreements, the litigation ends. Now, could this case cited by the decided by the trial court encourage clients to tell potential clients they don't need to follow signed agreements? Your Honor, the family law profession is very competitive. There's over 1,100 lawyers in the Colorado Bar Association family law section. The financial incentives in family law are sadly perverse. Under Colorado law, the attorneys work on a $1 per hour basis. The more the attorney, more hours he works, the more fees he can justify. Parties reach an agreement, the parties get paid a bit. The parties fight and litigate and fight, the family law lawyer gets paid a lot. Does that encourage mediation resolution? In this case, we had a former judicial officer of 18 years, who's now a mediator, testify that in this case, well, when an agreement is reached, the parties are bound to their agreements. These agreements.
Isn't unconscionability a factual question? I mean, don't we have to defer to the trial court's factual findings about what the parties knew, what they understood, and whether or not this was unconscionable?
Well, to some degree, we agree with the analysis on the factual, but in the Thornhill case, the appellate court wrote, "We're not bound by the trial court's determination that the agreement is conscionable." This appellate court is not bound by the trial court's determination as to whether the agreement is conscionable or unconscionable. I don't think the facts are necessarily in dispute. We just say that the trial court did not properly follow Colorado law in making its determination.
What about, can we talk about the statutory, because the maintenance agreement, or the entire separation agreement can be set aside for unconscionability under section 112, but also the maintenance agreement is separately not enforceable if it fails to follow the statute, right?
The maintenance agreement,
Or the waiver.
the court held that the wife's wife waived maintenance, but the court held that the wife's waiver of maintenance was not enforceable, and the court decided that based upon the Colorado law, but the Colorado law provides that the parties who are over the upper income of income for computing maintenance, which these parties were, in that instance, the maintenance guidelines don't apply, and the court's waiver said the wife's waiver of maintenance was not enforceable because wife didn't know how much maintenance she'd get under the guidelines, but the guidelines don't apply.
Let me pose this question to you. Assume that husband made $20,000 a month and wife made $1,000 a month, and they signed a maintenance waiver without computing the guidelines amount. Would you agree that under that subsection 7, it's unenforceable, right?
Not necessarily. We state that if parties who are sophisticated, who know the financial situation of the parties, and if there's no fraud or overreaching.
No, I'm not asking if it's unconscionable. I'm asking whether or not it's in violation of subsection 7B, which says that the court may not approve such an agreement if it's subject to the guidelines and the parties do not know what the guideline amount is.
That's on the maintenance.
That's where my question is focused, counsel.
Okay, just on the maintenance part, the law provides if the wife is aware of maintenance. So then we can get into the detail, was she aware of what the maintenance amount may be, or was she just aware of maintenance? In this case, it's clear that wife was sophisticated. She filed for divorce.
Counsel, now you're getting into factual disputes. I'm going to repose my hypothetical, okay?
Okay.
We just track my hypothetical.
Yes.
Husband makes $20,000 a month. Wife makes $1,000 a month. They're unrepresented by counsel. Nobody's looked at the maintenance guidelines. The parties sign a waiver of maintenance. Is that enforceable?
It depends upon other circumstances. If the wife.
I've given you the circumstances of my hypothetical.
Yes, we would argue that it is
How?
enforceable. Because if the situation is that the wife has additional substantial assets.
That goes to entitlement to maintenance, counsel. I'm asking whether or not the waiver itself is enforceable under subsection 7. If husband makes $20,000, wife makes $1,000, nobody looked at the guidelines, and nobody was represented by counsel.
If wife is sophisticated, aware of.
Where is the party sophistication listed in subsection 7B that prohibits the court from accepting that waiver?
We would argue that under the Manzo case and other cases that.
Any of them decided after the statute was in effect?
I'm sorry?
Any of those cases decided after the statute was in effect?
I'm not sure on those cases, but there are not, we have not found any reasonable cases that talk about the unconscionability or the maintenance not being effective under that circumstance.
Counsel, as I understand your statutory argument, it is the parties make too much money, therefore 7B doesn't apply.
That's correct.
And I am asking you, I'm giving you a hypothetical where the 7B does apply. $20,000 for husband, $1,000 for wife. Then doesn't 7B come into
I would say
effect?
under that situation, it could certainly be argued that the guidelines do apply under that case, so the court can certainly consider it under that case. We are arguing that that's not the case at bar, and there's a lot of other factors.
But no, you're really arguing that the parties make too much money, so they're not subject to the prohibition in 7B.
Correct.
But really, it's husband makes too much money. I mean, I think under my hypothetical, 7B is spot on. It's not enforceable because it's within the guidelines. But now suddenly you say instead of the husband making $20,000 a month and wife making $1,000, if he makes $25,000 a month and she makes $1,000, then it's enforceable under 7B. How is that a sensical reading of the scope and reach of 7B that's designed to protect against an enforcement of a waiver under these circumstances when the reason it's not subject to the guidelines is the party who's attempting to enforce it makes too much money?
Well, we understand the argument, but here we're looking at the entire situation of that. So we understand the court's argument, but we would still...
It's not my argument, it's also, I'm posing this as a question.
We understand the statute and how that works, but we're arguing that under the facts of this case, that the wife's waiver of maintenance was enforceable.
But one of the facts that you're hinging this to is they make too much money. Really, husband makes too much money. I'm trying to figure out how that is not an absurd reading of the reach of the statute. That if the party only makes quite a bit more money, but not outrageously more money than the other party, it's enforceable. But as long as it's over $24,000 a year, then the other spouse doesn't get the protection of the statute.
Well, sometimes the hard facts make for a difficult law. Again, we understand your hypothetical, and again, I would just state that that's not the facts of this case. I would like to reserve the remaining time if I could.
You may, thank you.
Good morning, may it please the court. My name is Kelsey Sundal, attorney registration number 51397. Here with me, I also have Andrew Haas, attorney registration number.
Could you hold on one second?
Sure.
I'm not sure where that's coming from.
I wasn't expecting a call. Anybody else? Sounds like a phone.
Is that
ringing.
It almost sounds like it's coming through.
We've stopped the clock, just so you know. We haven't even started.
That's weird.
I don't see any phone ringing. It sound like it's coming through the speakers, doesn't it?
Yeah.
Yeah.
Do you have the phone back there?
This is a new one for me.
You say that, but you never really know. It could have been you.
I don't want you to have to argue over that. Oh,
Okay.
There
I might have stopped Jennifer.
Jennifer?
It stopped. I'm sorry for that interruption. Please
No
start
worries.
fresh.
All right, may it please the court. My name is Kelsey Sundal, attorney registration number 51397. With me here is Andrew Haas, another attorney from our office, attorney registration number 25558. We represent the wife, Julie Harrington, in this matter, the appellee. So we are here today because the petitioner husband believes that the trial court erred and abused its discretion on 3 matters which the court had great discretion and latitude to determine. Colorado law grants the trial courts great discretion on matters related to separate agreements and maintenance because ultimately they are the fact finders, and their findings on the facts govern the same appeal. They are in the better position to determine the credibility of the witness, the testimony, and the evidence presented by the parties. In this case, the trial court heard extensive testimony in two hearings about the gross income of each of the parties, and importantly, the high standard of living throughout the course of the marriage. They also heard testimony on the distribution of the marital and separate property following the parties' separation, the parties' expenses after their separation, the length of the marriage, the circumstances surrounding the creation and filing of the separation agreement, and the creation of the sworn financial statements, as well as the health of each of the parties, especially focusing on the husband's glaucoma and his deterring eyesight. And then finally, they had heard testimony on the ability of each of the parties to work during the course of the marriage, after the separation, and in the future. This testimony, when paired with the pleadings, exhibits, and filings before the court, led to the extensive and in-depth findings of fact of the trial court in all of the June 2017 order, August 2017 order, and the permanent orders. In all of these pleadings and orders, the trial court applied the appropriate Colorado laws, including Section 1410-114, Section 1410-112, Thornhill, and Manzo, as the husband has also discussed here today.
And you agree that there was no overreaching here?
Could you hold on one second? I don't want you to have to argue over that. That's not fair. Plus, we can't really hear you very well.
I'm sure this is making for riveting internet viewing.
I promise it's not me.
All right, it's paused again.
Whenever Jennifer leaves, it stops, so I think
The
that's...
theme, we found the theme.
So you agree that there is no evidence of overreaching or sharp dealing here, right?
No, we
it's
don't.
pure-
Yeah, there was never a dispute as to that, and even at the trial level, that was never a contested issue. I think the parties had agreed at that level, and the court had acknowledged that fact and moved on to that second
So the
element of analysis.
unconscionability determination is solely based on the terms of the agreement, not on the circumstances of its making, right?
Not entirely. I think that the circumstances leading up to the creation of the separation agreement and the fact that the wife had contested it prior to it becoming part of the final orders are all relevant to determining whether or not it was conscionable, because she was caught up in all the emotions of it, and I don't want to, necessarily get buried in the facts because they are what they are. But the court
But he made
found,
right, the court made findings that one of the motivations was she asked for the divorce, so she wanted to make this quick and dirty and
Correct.
drafted a favorable agreement.
Correct.
But that was kind of self-imposed duress. It wasn't sharp dealing or overreaching by the opposing party, right?
there was no overreaching, but the duress, and you're correct that there was no duress, and I wouldn't say it was self-imposed. I think when you're going through a divorce, there's a lot of emotion
Circumstantial,
involved.
right.
Correct.
Imposed by the circumstances.
Correct.
And the court, with respect to unconscionability, the court could either set aside the maintenance waiver based on the 114, subsection 7, or based on unconscionability, right? Those are sort of two avenues to reject it.
Correct. So under 7B, that's where I believe husband's argument is focusing on the awareness factor. And there was extensive testimony as to that.
Nope,
Are you talking about the separation agreement?
You can set aside the maintenance agreement either under 7, 114.7, or under 112 unconscionability, right?
I believe the unconscionability 112 applies only to separation agreements, and 114 applies only to the setting
But
aside the
separation
maintenance.
agreements include a waiver of maintenance. I mean, so isn't an unconscionable waiver of maintenance as part of a separation agreement subject to the 112 conscionability analysis?
I guess yes, they could be. It's just a matter, it doesn't always have to be the case, but yes, that could in fact be the case.
But here, what the court relied on was not 112 with respect to the waiver maintenance, but the 114.7b, right? The 7b
I'm
being
trying to remember.
being that she didn't know about didn't know what the
Correct.
what the guideline maintenance was.
Correct, the awareness under 7B.
Let's talk about that statute.
Okay,
It expressly says that it only applies in proceedings that fall within the maintenance guidelines set forth in subsection 3 of this section.
correct.
How does this case actually fall within the maintenance guidelines?
So The maintenance guidelines are only a starting point. If you get into the legislative history, it gives why they exist in the first place. If you get into 3B, it applies and it says, can apply where the parties exceed the uppermost limit of the $240,000, which I believe is where the crux of the issue here is. But it doesn't require that, the only requirement in that statute is that you make additional oral and written findings if you exceed that amount or if you're less than that 3-year amount. It's not to say that 3 can't apply.
Well, no, but I'm talking about the 7B prohibition on accepting a waiver of the parties. Isn't there a condition precedent that the case must be subject to the guidelines? Now, you can still get maintenance even if it's outside the guidelines. A marriage of less than 3 years talks about what happens when there's a marriage of greater than 20 years or the parties make more. But it's not subject to the guidelines. It's subject to the maintenance statute, but it's outside the guidelines, isn't it?
When you're saying it, I just want to be clear on your question. What's outside the guidelines here that you're
When
asking?
the parties make more than $24,000 a month combined. It's outside the guidelines. It's covered by the statute, but not.
Technically, yes, you're
Well,
correct.
But isn't that the condition,
yeah.
the condition of
Yes.
that 7B applying?
You're correct.
Then how can 7B in this case be a basis for rejecting the waiver of maintenance? Because isn't that what the court hung its hat on?
The court hung its hat on it, but it had also found and used 3B and A to get to that point. So it was using
When you say 3B and A, I'm sorry.
1410, 114, 3A.
So you're saying of extrapolating beyond the guidelines?
Yes,
Well, that's to calculate what it views a guideline amount would be. But in order to even reach that question, the trial court had to reject the party's waiver, right? Because the court doesn't have anything to do if it accepts the waiver, then we're done. So it first had to reject the waiver, right?
correct,
And it relied on 7B to reject that waiver, right?
correct.
And how is 7B, under these circumstances, a proper basis for rejecting the waiver, the way the legislature wrote it?
I guess in my mind, because the court found at that trial, at the fact-finding level, that they were going to apply 114.3A and B, I mean, granted they're a guideline, I still think that just because that number exceeds it, it's just saying it's only saying that you have to have these additional findings of oral and written findings. It's not to say that 3 can't apply. 3 still applies because you're still using that same calculation, you're still using the same justification to apply the statute itself in 3.
What? Okay.
The statute says, in any proceeding that falls within the maintenance guidelines set forth in subsection 3, a proceeding only falls within the maintenance guidelines if the parties' combined income is less than a certain amount. Isn't that true?
Correct.
You're denying that and say, but if it's above that, yes, there are other things in section 3 that the judge applies, but the proceeding doesn't fall within the maintenance guidelines if the parties' combined income exceeds whatever the amount was at the time, right? The judge here then goes on to say, in the latter part of that paragraph, the unrepresented party has not indicated that she's aware of the maintenance guidelines. Now, she did indicate in the separation agreement she was aware that there was maintenance guidelines out there, but what she said was she didn't know the exact amount that she would get. She only found that out when the court administrator told her.
Right, that's correct, but if you look at the record and you go back to, I believe it's paragraph 30 of the court order in June, the court had found that there is no dispute that wife was unaware of the maintenance guidelines when she signed the separation agreement pro se. So they had found that she wasn't aware by definition of that statute.
Although, all right, fine, so she satisfied the unawares. But if as Judge Welling has tried to show you, if the preliminary requirement of B is that the proceeding fall within the maintenance guidelines, and this proceeding does not fall within the maintenance guidelines, her awareness of maintenance guidelines is irrelevant to applying the statute.
I still think that, I mean, by the letter of 1410, or I'm sorry, 1410, 114.3, you're correct that it doesn't by definition fall into that category. That being said, as you had alluded to earlier, there's other means of finding that that maintenance amount should not be enforced.
Yes,
But
if
the
it's
trial court-
unconscionable.
Right, the trial court didn't make that finding, though,
Yes.
as to this waiver of the maintenance. You only made that finding of unconscionability as to the property division.
But then they went on further and did a full other hearing, a second hearing after the finding about the waiver of the maintenance, and had a second hearing with essentially the same facts and findings, came out with an order and calculated the amount of the maintenance under that same information, and finding that maintenance was appropriate in this case. So the fact that they even found that it was appropriate, to me, also states that, you know, it was unconscionable, because the finding and the calculation and going through the in-depth calculation of getting the $4,000 a month for 40 months, that in and of itself tells me that the court knew all along that this was unconscionable. Whether
Well-
they actually delineated that is a different story.
Waiving maintenance, essentially agreeing to waive maintenance when one is entitled, would be otherwise entitled to maintenance or eligible for maintenance, doesn't make the waiver unconscionable, right? I mean, there's a difference between a waiver being unconscionable and you're just waiving maintenance that you would be entitled to. So just finding that she was entitled to maintenance doesn't result in a finding that her agreeing to waive that sum is unconscionable, right? I mean,
Correct.
and the trial court did not make an unconscionability determination. Instead, just found it can reject the waiver on a statutory basis that it sounds like you're agreeing does not apply.
I don't want to say that I'm agreeing to that, because
I'm sure you don't.
I still think that just because the number is higher than that amount, all it's requiring is that you make additional findings. I don't think it's saying that, you know, you have to fall within 3A and B for 7. I mean, I know 7B says that 3A, if it falls within 3, then it falls into that category. But I don't think that 7B can limit that much and say that just because the party's income exceeds it, and just because the maintenance calculation is possible, that you can't find that 7B applies.
Well, or you just don't go through 7B. You still have a backstop of unconscionability, right? Even if 7B doesn't apply, there remains a backstop of the waiver being unconscionable and therefore subject to not being enforced. But my concern here is the court potentially erroneously relied on a statute and didn't make the findings on unconscionability with respect to this because it thought the statute applied. So why doesn't this have to go back down to the trial court to make that determination?
I guess I just don't see that it's necessary to find unconscionability on the waiver of maintenance. I don't see anything in the statute that requires that be a finding.
If not unconscionability for a basis for setting aside a waiver of maintenance, what is the basis for the court then to reject a waiver of maintenance if not unconscionable? Or 7B?
Fair enough, you could make the unconscionability argument. There's different ways you could structure that when it goes back down, but to answer your ultimate question, sending it back down, I think, is ultimately going to lead in the same result. They're going to go through the same calculation that they did. They went through 1410, 114.3 A, B, C, and D to get to that calculation. They used the guidelines as a starting point. They used the party's income. They did a full calculation. They considered the wife's ability to make payments and to meet her expenses and her ability to work. They considered the husband's income, his ability to work, and his health, and everything else that encompasses the end result.
So do you think there's an
if you
implicit
send this back
unconscionability finding in addition to the statutory finding?
down- I believe so.
Implicit, but I thought you said earlier explicit. You're not saying anything in the permanent orders kind of went back and said waiver of maintenance is unconscionable. Or if it is, show me where it says that in the permanent orders, because I don't see that.
I was going off of the order of the court. I didn't look at the permanent orders recently. I don't know what you're referring to.
I don't know what you're referring to, because I thought you said that there was an unconscionability suggestion in the later order. Which order suggests that the waiver of maintenance was unconscionable? If we can find it in an order, we
I
can
might have
look at that.
misspoken. I don't recall saying that,
Okay,
but,
okay.
I mean, I could have easily misspoken.
But
If that's the case, just to clarify, I
go ahead.
believe that it's implicit, the unconscionability argument in the waiver of the maintenance. If not, by statute, it would be implicit. So with that, I would request that the orders of the court hold and that the maintenance and the separation agreement findings stand.
Great, thank you, counsel. I again apologize for the interruptions earlier.
Your Honor, my remaining time, I'd like to hit the extremely important issue where the parties are held to the agreements in separation agreements, where there is no fraud or overreaching. There are many mediations. At the end of a mediation session, 5:15 in the afternoon, the parties will often have a mediation agreement. They'll handwrite terms onto it. The parties will initial it, and the parties are bound to those agreements. Mediations are extremely important here. And as the judicial officer, who's now mediator, testified, and our experiences, parties are held to their agreements at mediation. And the reason that they're signed here and now at the end of a long day of mediation is because if they could have second thoughts when they go home, and then it just lead to litigation. But if they sign the agreement, they're held to the agreement.
Well, no, the statute gives an explicit out in 112. They are not held to the agreement if it's unconscionable.
Well, I agree, if it's unconscionable.
Well,
But
that's the issue before us.
It's not a low standard.
yes, that's the issue before us, but the question here is one, is this what the wife ended up with the agreement that she drafted, signed, filed with the court, was that unconscionable? We are concerned about the public policy provision saying that if wife has second thoughts, she can just go in and say, well, I find it unconscionable.
This is far more than buyer's remorse or waking up Monday morning and regretting it. What you're asking for is a rule that says that in order to find unconscionability under 112, you need both some sort of overreaching and manifestly unfair conditions, or unfair terms, right? And
Would
that
agree.
manifestly unfair, you're asking us for a rule that says manifestly unfair terms alone, without some kind of overreaching, as a matter of law, cannot be found to be unconscionable. Is that a rule?
That's correct, and that's what this Colorado Supreme Court ruled in Manzo. And they ended up with an agreement that was extremely unfair, but there was no overreaching, and the Colorado Supreme Court said you are bound to that agreement.
Well, but the unfairness of that was sort of the parties knew that there was some risk that this may not. Both parties were kind of assuming the risk that maybe the house would sell for a lot more, maybe it would sell for a lot less. So, but here, that they weren't assuming a risk. The terms at the time that they signed them, according to the court's findings, were manifestly unfair.
Well, that's a main part of our argument. Does what the wife ended up with the agreement she drafted, was it unconscionable? And we believe that this trial court has the ability to find that what the wife agreed to was not unconscionable under the circumstances of this case. And we just ask that the trial court's position that the wife signed the agreement, it should not be followed.
Great, thank you very much,
Counsel,
counsel.
before you leave, I need to ask you one more question.
Yes,
If we
please.
are to agree with you that the waiver of maintenance was not properly ruled on by the trial court, and we have to send it back for more proceedings on the waiver of maintenance, do we also have to send back the property division, even if we find it wasn't unconscionable?
Great questions.
That's why I asked.
And many of the cases do state that when there's issues of property and maintenance and they're all combined, that the trial court will issue all of those. I don't believe that that's the situation here, though, because I think that the crux of the situation was the overall agreement unconscionable. So I think that the one in this particular case, under the facts of this case, every case is different, that could be.
We could send back just the waiver of maintenance and leave the property division if we disagree with you on the unconscionability ruling.
We believe that could be appropriate. We don't think that the trial court is necessarily bound one way or another in this case with the substantial assets that the wife is receiving.
Okay.
Thank you, counsel. Thank you to both counsel for your excellent arguments. They will be helpful to the court. This case will stand submitted and a written opinion will issue in due course. That concludes our morning docket. This court will be in recess and the bailiff may so announce.